soon as talk became serious about the bankruptcy, then obviously the city's collection as an asset was obvious to everyone. Some of us harbored what turned out to be forlorn hopes that the governor would decide that it was politically the bravest thing to do would be to take it off the table, but he took another course. He decided I presume took the emergency manager's advice to leave us on the table. And I've had one meeting with two senior individuals, a restructuring specialist and a bankruptcy lawyer, with my chairman, Jean Gargaro. And in that meeting, it was made clear to us that if we could come up with a certain sum of money, which was not defined, but sums like, I don't know, $20–30 million a year for 20 years, or then maybe we could we could do something about signing the collection over. Suggestions were made that we could, if we wouldn't sell art, that perhaps we could find ways of monetizing it, and suggestions were made about renting the collection. So we have spent considerable time doing our due diligence, looking at the possibilities of what might be feasible. And from our point of view, and by the way, of course, Christie's was engaged to evaluate the collection, and as the press release said, also to help the DIA come up with ideas about how it might monetize the collection. But there is no way. Basically, if you're going to monetize the collection, you sell it. We did, when we needed some revenue a few years ago before the tax was passed, we put two of our main collections on the road, and it grossed something like $750,000 for two collections going on the road, which is a completely different order of magnitude. This is, I think, ultimately a political situation. We cannot get to the governor, and as you can imagine, I have some rather influential political individuals associated with my museum, but basically we've got a rather effective stiff arm, and in a kind of in a way a cloud of unknowing. And we're really in the situation of preparing for eventualities that we hope will not happen. But just yesterday, at a public hearing, the lawyer for the emergency manager was accused of bargaining in bad faith by some proposal that was put forward, not having the DIA's art collection on the table. And his response was, but haven't you heard? The Attorney General's opinion is that it can't be sold, and absent litigation, no works of art will be sold. So suddenly entered this another form of, I don't know, limbo, purgatory, whatever.
First, unlike in corporate or commercial bankruptcy, there are significant limitations on the court's power in municipal bankruptcy, very explicit in the statute, and they grow out of the 10th Amendment to the Constitution, which says that all powers not vested in the federal government or reserved to the people are reserved to the states. The Supreme Court said, therefore, although municipal bankruptcy is permissible for Congress to create a municipal bankruptcy statute so that the cities can use the federal government's bankruptcy power, in doing so, neither Congress nor the court can interfere in any way with the state's political or governmental powers, and may not interfere with any of the city's property or revenues. Very important limitation that is not present in any commercial bankruptcy case. In addition, there's a provision in Chapter 9 that says the court may not confirm a debt adjustment plan, the document that gets the city out of bankruptcy, unless the city is not prohibited by law from taking any action necessary to carry out the plan. In other words, the federal bankruptcy law does not preempt or take precedence over or trump state law that would apply to the operation of the city. So against that, people always say, well, will the courts sell the art? Will the creditors require that the art be sold? That's the question we often hear. The answer is only the emergency manager, appointed by the governor, as Graham mentioned ago, to take over the management and governance of the city of Detroit, displace the mayor and the city council. He is the government of the city of Detroit at this point. Only the emergency manager, not the court and not the creditors, can decide whether to sell the collection. And even his decision is going to be subject to two important constraints. One, what does state law say about his authority to sell? And two, the emergency manager statute says that if he wants to sell any assets worth more than $50,000, as you saw some of those items may be worth more than $50,000, he needs the governor's express approval on each sale. Normally, in a regular commercial bankruptcy, all of the property that the debtor owned at the time of bankruptcy becomes subject to creditors' claims. And the court exercises complete control over that property. But when a court determines what property a debtor owns, the court must look to state law. So to determine whether the debtor owns the artwork in the museum in a trust or whether it owns it outright and what the city's rights are in that property, the bankruptcy court must look to state law, not to federal law. And there's a specific provision in the bankruptcy code which actually doesn't apply in a Chapter 9 case, but I'm going to give it to you by way of analogy. In a corporate case, if the debtor corporation holds assets in trust for a third party, the bankruptcy doesn't break through that trust. The only thing that the court has control over is the corporation as a trustee, but the beneficiary is unaffected and the property is unaffected by the corporate bankruptcy. So that's certainly going to be true in municipal bankruptcy, where there is no control over property of the city that is in bankruptcy. The Senate Majority Leader requested the Attorney General's opinion on the ownership of the art and how it should be treated. And he gave, as Graham said, a very long opinion that the city holds the art in a charitable trust and that it may not be sold or transferred or encumbered to pay claims of creditors or for any other purpose, claims of creditors of the city or at the museum actually, or for any other purpose other than to maintain it, to enhance the collection. Obviously, creditors, you got retirees, pension fund, bondholders, creditors disagree with that opinion. That opinion is, the courts said it's persuasive, but it's not binding on the courts, not legally binding. So the matter is either going to have to be litigated, some court is going to have to decide whether the Attorney General's opinion is right and the art is protected or not, or it's possible that there could be a settlement of it. Now, who knows what a settlement might entail, but whenever there's litigation, parties always try to settle. For the most part, these things get settled, and that's how a company or a city emerges from bankruptcy. The way Chapter 9 is written, creditors may not propose a plan. Only the emergency manager may propose a plan. This goes back to the idea of the city staying in control and not ceding control either to the bankruptcy court or to its creditors. As I said, the emergency manager is going to want to reach agreement with the creditors on a plan. That's the nature of the bankruptcy process. The creditors, as you heard, are demanding that there be value from the collection contributed to the amount that is going to be repaid to creditors. And if there's no agreement, the court is going to have to determine whether the court can confirm a plan that, depending on what the EM wants to do, either does or does not include the art or sale of the art or monetization of the art. That's a future chapter that has not yet been determined. Stay tuned. We'll talk to you again, I don't know, a year from now? Who knows?